In this module, we're moving on to the practice of restorative justice and having a bit of a look at some of the different ways in which restorative justice has been implemented, and to look at some of the ideas that have been used to support that practice. As we discussed last week, there's very much an ongoing relationship between the development of practice and the development of the ideas which explain why the practice works, criticize where it doesn't, and look at the importance of development for the future. And this is, I guess, quite different to the way that things ordinarily work in criminology, because in criminology we often get practices that were developed 200 years ago and have remained pretty much in place since then, and we've got a lot of criticism of it, and we've got the established ideas that they were based on, but we don't see this ongoing development. We don't see this connection between theory and practice that we do in this particular area. So it's quite an interesting area, and I think it's one where we don't have that temptation to see theory as this sort of disembodied, removed, ivory tower perspective, because it's actually the roles of the theorists are absolutely fundamental in the development of new stages and new forms of restorative justice. All right, so last module we looked at sort of the different definitions of restorative justice. I want to reiterate this by talking about some of the core principles of restorative justice. And this comes from the article by Bazemore and Green, which is, again, as usual, is in your notes. And they say that there are three principles that are the foundations of restorative justice. One is the principle of repair. Justice requires that we work to heal victims, offenders, and communities that have been injured by crime. So the focus is on the harm and the repair of that harm. And it's like the actual harm caused by the crime, not you've committed a harm because you've defied the laws of society or you're a bad person or whatever. It's actually looking at, well, what did they do and how did that harm others? Second principle is stakeholder involvement. Victims, offenders, and communities are involved in various different ways in these approaches. Again, something which is relatively recent. It didn't happen in the past. In the past, we looked last week at Nils Christie talking about conflicts as property and conflicts being stolen by the state for themselves, and we very much get that sense of a crime has been committed, the victim gets pushed off to the side, and the state says, well, you may have actually attacked this person, but the person who's really suffered is society, because you've broken the rules. Or quite literally in the English and Australian system, it's the monarch. It's now the king. It's like, well, you may have punched Bob in the face, but the person who's really suffering here is King Charles, which is why our legal system always puts the crown, the king, against the defendant. It does seem quite silly when you put it like that, but it does emphasize the position that the victims are put in. So the second principle that Bazemore and Green talk about is that idea of actually having the victims and the rest of the community involved and not letting the state push everyone out. The third principle they talk about is a transformation in community government roles and relationships. And that is, it encourages us to do, as we are doing right now, rethinking the role of government and not thinking about crime as something which is the government against individuals, but thinking about, well, what crime actually is and what is the government's role in repairing damage. And that asks a whole series of different questions than we're used to in terms of, punishing offenders and making sure that they don't break the laws of society. It's more about, well, how do we diminish harm? And in some situations, offenders are not all equal. There are many situations where offenders are also victims, have been previously victims, and there is a need to break cycles of violence. There's a need to do more than just punish an individual. There's a need to be involved and change social structures and change things in society to stop these cycles of violence occurring. And you'll know from your other criminological studies that there are plenty of situations that are that are very difficult to resolve, involving domestic violence, involving sexual abuse, where it is more than just an individual one day gets up and decides to commit a crime. There's more required for society to be involved in that. So Bazemore and Green, I think, give us those three fundamental ideas that I think are very useful to us to identify where restorative justice works, repair, stakeholder involvement, and transformation of government roles. Why are these principles important? There's a quote here from their book that I'll read out that I think is an interesting one to think about. They say, because no practice or process is inherently restorative, principles, as generic commitments that reflect core values and ideal standards, provide general guidelines that differentiate restorative justice from other perspectives. Principles also prevent co-option of the model and keeping practice consistent with restorative values, while allowing the continuous evolution and adaptation of practice to different structural and cultural contexts. So they're saying that if we don't have principles when we do something, it's very easy to drift away from what we're supposed to be doing, and our principles can get co-opted for other reasons. And there's a classic example of that with family mediation. A long while ago, the family mediation was voluntary and it was very successful, and the Australian government decided to therefore make family mediation compulsory in divorce proceedings. As a result, it's no longer successful because the voluntary nature is very important. And also there's a principle that ethical mediators work by, is that you never mediate power imbalances, or severe power imbalances. And where there's things like domestic violence, you never, ever, ever mediate domestic violence. It's just off the record. But now, as the Australian law mandates that all family matters get compulsory mediation up front without any questions asked about violence. So I think it's an excellent example of how you can have a system. I mean, this is not criminal law, but this is involving family law. But you've got a system that's working, and it's working because the principles are really good, and then the government decides just to force it on everyone, and they mess it up, and they ruin it for everyone. And then at some point they'll just say, oh, well, mediation doesn't work. Mediation's terrible. And I know you may have been through the process yourself. You may know people who've been through the process yourself who'll tell you how terrible compulsory family mediation is. Well, it's not supposed to be like that. That's not the way it's supposed to work. All right, another principle that we talk about this week is having safeguards. And it's very important that you set up, and again, this is again brings us back to that example. But we look at the different safeguards that need to be in place to make sure that the system operates well and protects those who are involved. Now, in your readings, you've got the UN document on restorative justice, and that's worth reading through and having a broad overview of the different principles. But there are some that are the important ones. Things like the right to consult legal counsel is important. People shouldn't be coerced, either victims or offenders, into a mediation or a restorative justice process without checking out what their legal rights are. And this is particularly, I guess, important for offenders who may feel pressured or told or at least believe that they'll have an easier time if they go through this process, and not realise that that's not necessarily guaranteed, or people who are innocent, who are compelled into this process with this idea that if they go through the normal process, they'll just get wrongfully convicted, and that this is an easier option at the end of the day. So the first of those safeguards is very important. It's the important right of access to legal counsel. Others are the right not to participate. People shouldn't feel compelled to participate in these processes. If they want to go back into the conventional system, they should be allowed to do that. And a lot of offenders do prefer to go through the normal system rather than to face their victims. In many ways, it's much easier to sit in a courtroom, sit in the dock, ignore the process that's going on around you and deny any sort of responsibility for what you've done than to actually face the person who you've victimized and actually look at the consequences of what you've done. There's also a lot of sort of subcultural material that, again, you may have looked at in other criminology areas, that particularly for young offenders, going through the court process is a rite of passage in some subcultures, and they may want to go to, for pretty bad reasons, but they may want to go through the conventional process so they can, be branded criminals and achieve a sense of authenticity in criminal subcultures. But that should still be their right to do that. They should be, and of course, victims obviously should have the right to be involved or not. It does create some interesting issues where an offender wants to go into a mediation process and the victim doesn't, and there are different. Some of the models that we're going to look at don't require the victim to be there, but your conventional victim offender mediation, if your victim doesn't want to be involved, that's the end of the story. And another of the safeguards that's included is confidentiality. The proceedings are confidential. Again, that's very important to make sure that things are run ethically and are protected. So what are the different types of restorative justice process that are practiced? There are three main ones: conferencing, victim offender mediation, and circle sentencing. Conferencing is the one that's closest to the existing system, but when you get to the point of sentencing of an offender, you actually have a conference model where you have a whole lot of people, including the victim, including people in the community, people who are supporters of the offender, involved in a conference where you decide what the appropriate solution, the appropriate sentencing is in that case. So up until the point of conviction, very much like the old-fashioned criminal model, but then when you do hit a situation where the person has either pleaded guilty or been found guilty, and quite often victim offender, a lot of these restorative justice processes really focus on people who plead guilty rather than people who are convicted. Then you have this group conference, and the judge or magistrate, usually magistrate, presides over the proceedings to make sure it all works well, and basically gets a group consensus over what the solution is going to be. And often that involves elements of restoration done by the offender. And it can start with something like an apology, but it can also move into them committing to do certain work to repair the harm they've done, and maybe not with the offender themselves, but they may agree to do work with a charity or work with a community group to demonstrate that they're sorry for what they've done. Okay, that's conferencing. Victim offender mediation is where you have victim and offender in a process guided by a mediator. The important thing about mediation is the mediator doesn't make a ruling. In conferencing, a magistrate will make a ruling at the end of the day based on what they have seen, but in victim offender mediation, it's based on the victim and offender coming to agreement. The mediator just guides the process and helps people come to that solution. So, different sort of process. And the third one we talk about is circle sentencing, and that's generally used in where there's Indigenous offenders, and that's where the Indigenous community, the Indigenous tribal council or whatever are involved in the sentencing process. So that's generally where the Western courts defer to the pre-existing Indigenous practices. How does it work in Australia? We have youth justice conferencing in most states. It's by far the most popular form of restorative justice. And we have conferencing in a couple of states for adult offenders. And a couple of states have experimented with victim offender mediation. And even circle sentencing is not used very much. So Australia is very much focused on young offenders, and it's focused on the conferencing model. We have had experiments with the other versions, but we don't have any kind of consensus as to how we go about it. And in the next few weeks, we'll look at some of those specific examples of who's done what and what have been the findings. The last thing I want to touch on in this video is the different theories or ideas that have developed alongside these practices, to give you an idea of how we've developed this understanding of the process and how it worked. And particularly with things like victim offender mediation, this was done reasonably early on without a framework, and then it was surprisingly positive, and especially surprisingly positive from the victim's perspective. There was a lot of feedback from victims, again, who were terrified of re-victimization, were terrified of the offenders, and then went into victim offender mediation and went, oh my God, they're 14 years old. I don't need to, exist in terror of what happened. This is another person, and they did a terrible thing. But I don't have to keep this image I've got in my mind of this terrible predator who did these terrible things, and just, going to find someone else is going to find me, and all these kind of things that victims are almost encouraged to develop in the conventional criminal justice system. The victim offender mediation, conferencing, and so on, all those restorative justice processes tend to be very cathartic for victims, who can sometimes end up being quite positively disposed towards the offenders. There was one famous case in New Zealand that's been pushing ahead quite strongly in this area, of a victim who ended up adopting the offender. She was an older woman who had been living in terror of that there was a burglary, and she never saw who was involved, but she was living in terror of this criminal out there who had stolen her stuff and been through her house and violated her privacy. And through the mediation process, she realized that the offender was just a kid, and was quite a young kid at that, and had no family, no options, and she took the kid in, and they became a family out of it. Now, you're not going to expect that's going to happen out of all crimes. That's obviously a very rare occurrence, but I think it's a good example of how a victim goes from being absolutely terrified of re-victimization to actually being really heavily involved in the solution to the problem. So I'm going to look at 3 different theories here in the time that's left. Reintegrative shaming theory, procedural justice theory, and interaction ritual theory. And we're going to come back to these later in the term, but I wanted you to just have the broad brushstrokes of what these ideas were about, so that going forward, these things would make more sense. So the first one, reintegrative shaming theory, is the creation of an Australian criminologist, John Braithwaite, and he saw the importance of shame in the process, and then asked in restorative justice processes, and then asked, well, we also shame offenders in the normal courts. Why doesn't that work? Why does shaming someone in the restorative justice context work, but being sat up in a courtroom and being told shame, shame, shame doesn't? And he talks about there's really 2 different forms of shaming. There's stigmatizing shaming, which is what we do in the conventional courtroom context, where we say, you're a terrible person, you're going to be convicted, and you're going to pay for your crimes, where you not only shame what the person's done, but you stigmatize them as a person, and you put a label on them as a person. He says that the other, what restorative justice does, is reintegrative shaming, and that's where you say what you did was a terrible thing, but if you are able to show that you're sorry, we will reintegrate you into society. And again, you're not going to make any headway with these ideas with people who watch Fox News or probably most of the people who are on Facebook, because people are, trained by media and they're trained by social media to be crying out for blood and revenge and everything else. But that doesn't solve anything, and generally makes people worse as part of the process. And reintegrative shaming is based on that idea that we give people another chance. Now, obviously, this is a form of justice that works best with young people, and it works best at the earlier stage before people become hardened into their role as offenders. Again, another theme we're going to talk about later is, where is it most appropriate? But we'll find that, most people don't start out as Hannibal Lecter. Most people start out, doing minor offences, being put into the system, and then, becoming worse the longer they have contact with the system. So reintegrative shaming says that just putting people into the system and giving them a label is not the way to go. And particularly early on, if we can actually give them an opportunity to make amends for what they've done, and reintegrate them back into society, then that's a good thing, because then we're going to stop that person going down that criminal career path. All right, the second one I want to talk about is procedural justice. This is a theory by Tom Tyler. And he talks about the experience of fairness felt by people in the criminal justice system. And he said, this is a little bit sort of to the side of restorative justice, but it's very important. He says that if people feel that they've been treated fairly, they are much more likely to engage with the system. If they have a say, if they're involved in the decision-making process, so like with conferencing and things like that, then they are much more likely to say, okay, fair enough, these are the things I need to do to change my behaviour. I will desist from crime. I will take these lessons away with me. However, the contrary is where people don't feel listened to. They don't feel as though the system is fair. What they're going to come away with is a grudge against the system. It's going to push people further into criminal behaviour, or into cynicism. I mean, this approach applies to the victims as well. Where victims feel that they're heard, they feel like they've been part of the process, they are much less likely to be cynical. They're much less likely to have fear of crime. They're much more likely to be satisfied with the process than the conventional model, which is you're a victim. We don't really want to hear from you, but we might call you in as a witness. And if you don't want to come in, we're going to force you to be a witness. And we tend to treat victims very badly. So the procedural justice idea is that if you can have a fairer system of any sort, restorative justice gives us one way of going, but if we can do anything to make the system fairer, then we're going to be able to preserve the relationship of trust that's going to get better outcomes for offenders, better outcomes for victims. The last theory I want to bring up here is interaction and ritual. This is based on the work of Randall Collins and applied in the restorative justice theory field by Meredith Rosner. So you'll find both of these theorists referenced. An interaction ritual is almost a kind of an anthropological approach that looks at where the ritual of the justice process, be it Indigenous justice or normal criminal justice process, what that means about the collective in society, and how the ritual caters to collective emotions, how rituals lead to group solidarity, and develop positive outcomes at that broader social level. So the first two theories that we looked at very much focused on the impact on the individuals. Interaction ritual theory looks at, well, what does it do for society? We've got crime, harm, creates a damage, it creates a tear in the social fabric. What is the impact of restorative justice on actually healing that? And we know that quite often, particularly when people get, re-victimized and get labeled as offenders, that social fabric just gets torn further and further apart by the criminal justice process. Whereas the argument from the interaction ritual perspective is that restorative justice actually heals society, not just the individuals. There's a quote here from Meredith Rosner. The current theory of restorative justice does not go far enough in exploring how collective emotions can lead to emotional and behavioural transformation. Interaction ritual theory is suited to explain how this works because the sequence and flow of interactions are patterned, ritualized, and relatively predictable. So Rosner says there are 4 key elements for restorative justice: shared focus through conventional rhythm, conversational and power balance, turning point, and public displays. Now, we're not going to go through those in depth today, but if you're interested in this explanation for restorative justice, it's definitely worth following up on Rosner's idea. And it's one that has much broader impact, I think, throughout society, and thinking about, well, what does the current criminal justice system do, and what harms does the criminal justice system do to society more generally that we can try and remove? So, it's not just a question of the harm done to a offender by a victim, but how does the unfairness or unjustness or wrong orientation of the criminal justice system cause bigger ruptures throughout society? So there's something to think about, and we'll explore that a little more, and we'll talk about that in the workshop this week.